first story, this bulletin, Lagos-based legal practitioner Kalu has expressed disapproval over the judgment of the Supreme Court nullifying the trial of former governor of Abia State, Ojuzo Kalu, his firm, Slok Nigeria Limited, and Jones Udegu, a former director of finance and account of Abia State government. Reacting to the Apex Court decision, the senior lawyer in his contributions noted that although the decision of the Supreme Court was in order, it however overshadowed the gains of the administration of the Criminal Justice Act as it relates to speedy dispensation of justice. In a chat with Galaxy's Kelly Giga, the lawyer says the nullification of Kalu's conviction was a demonstration of the Nigerian legal system's capacity to serve the interests of pampered members of the dominant class.
And I don't agree with the Supreme Court, and I know majority of Nigerians will not, agree with them. Although, in the times past, there's a decision, Nogunaya and Okudo, where the particular judge was elevated to the Court of Appeal. He has heard a matter. He came back to the High Court to deliver the judgment. And where on appeal, the court said no. The Higher Court said no. You have since you have been elevated to a higher court, from that day you cease to be a judge of the lower court, and for that reason you can no longer pass a judgment in the name and for acting as a judge of the lower court, having been appointed and sworn in as a judge of as a justice of the Court of Appeal. Now, in this kind of situation, how long can we continue to live like this as a country in 21st century where everything is developing? A judge has had a matter. What miscarriage of justice has been occasioned to the man? What has he lost? You are not saying the evidence against him was weak. You are not saying that the trial was no, but you are saying that because Justice Idris had been elevated to the Court of Appeal, he couldn't have given that judgment. He has no jurisdiction to give the judgment at that time.
Speaking on the way forward, Kingbolu, while agreeing with the judgment, however, said the Constitution must first be amended to empower elevated judges, sit and conclude cases they were handling before promotion.
Included in the Constitution, since the Supreme Court is saying the Constitution is superior to Administration of Criminal Justice Act, and the Administration of Criminal Justice Act cannot be relied upon, and that the fiat, the section granting the President of the Court of Appeal power to issue fiat is invalid. So we have to now amend the Constitution and ensure that there is a provision there to say if you have been elevated to a higher court, you have the right to still deliver your judgment or conclude that matter that has been part had.